after publication, if no opposition is filed, this is when the change happens. If it's in use, it goes to registration. You'll get your registration certificate, barring unforeseen circumstances. Okay, you always have to say that. They always say that. But, generally, if there's no unforeseen circumstances, if there's no opposition and it's in use, you get your registration. However, if it is an intent to use application, you do not get registration. You get a notice of allowance. So hello, everybody. Sharon Adams here to talk about trademarks again. This time I'm going to talk about the difference in the timeline between filing an intent to use trademark application and an in-use trademark application. An in-use trademark application is one where the applicant is currently using the trademark for the goods or services that are identified in the trademark application. That's fine. An intent to use trademark application is when the person or the applicant knows they're going to be using the trademark, but they're not yet using it to provide goods or services. Sometimes that happens when people are in product, planning and they're doing their packaging. Anyway, there's different reasons why people file intent to use trademark applications, and the timeline is different for them. Now, to start, I do recommend a trademark clearance search for every trademark application. However, I'm not going to discuss that in this video. We're starting here today with a trademark application being filed. So I made this little thing because I thought that perhaps it would be helpful to just have a visual of what is happening. So up here, we file the trademark application, okay? I'm trying to get the video to show everything. Okay, yeah. Then we wait 8 months later, 8 months approximately, for the USPTO to review the application. It can take longer, it can take less time. I'm just using 8 months because that's what it's been for a while. So anyway, after about 8 months, okay, the USPTO will review the application. At that point, there's 3 options that can happen. They can refuse registration. I'm not going to go over what happens if they refuse. That would be for a different video. They could allow the applications with changes, like sometimes they require maybe, let's just say, an amendment to the description of the mark. That happens. Or else sometimes it goes right from USPTO review directly to allow. That's fantastic, okay? At either of these, though, you get some sort of a communication from the USPTO after about 8 months. One of these happens, okay? There's other options, but these are the main 3. Okay, so if it is allowed, if you've made the changes, and then you've gotten an approval and it's allowed, or if it was directly allowed, if your trademark is on the principal register, again, a subject for a different video, but if it is on the principal register, it goes to publication. Every trademark application that is going to be registered on the principal register is published for 30 days, published for opposition. That means that third parties have the chance to oppose that trademark registration before it's registered. So it's published in what's called the Official Gazette, the U.S. Patent and Trademark Office Official Gazette, and any party that feels they may be harmed can file an opposition during that 30-day publication period. Okay, if an opposition is filed, again, that just goes off this paper, not something for this video. Let's just say no opposition was filed. Hey, fantastic. You've progressed. Now, this is the difference right here. This is what happens. Everything is pretty much the same with its intent to use, or if it's in use. This timeline is pretty much the same. And after publication, if no opposition is filed, this is when the change happens. If it's in use, it goes to registration. You'll get your registration certificate, barring unforeseen circumstances. Okay, you always have to say that. They always say that. But, generally, if there's no unforeseen circumstances, if there's no opposition and it's in use, you get your registration. However, if it is an intent to use application, you do not get registration. You get a notice of allowance. So the timeline is the same, but with an in use, you're done. You get your registration. Okay, you're done. Whereas if you have an intent to use, you're not done. You have additional steps, and that's on the next page, which I am going to talk about. but what you have is a notice of allowance. Okay, went here, started with notice of allowance. Like, okay, it's supposed to like line up. Yeah, notice of allowance. Okay, that's kind of like the same. You get your notice of allowance. Okay. Notice of allowance. It's a date. It's sent out on a specific date, and it's a very important date. 6 months after the notice of allowance. You have 6 months. Any applicant has 6 months to file either a statement of use showing that they are using the trademark in commerce, or to file a request for extension of time, which I abbreviate as RFET, request for extension of time. So if you file a statement of use, SOU, and if the USPTO accepts it, hey, you're registered, you're done. Each one of these filings has a US Patent and Trademark Office filing fee per class, okay? This is why it can add up to a lot more money if your trademark application is filed as intent to use and you don't use it quickly, okay? So that's kind of what I'm trying to get at here, because people ask me this all the time. So let's just do it again. Notice of allowance, 6 months go by. If you file a statement of use, if it's accepted, you'll get your registration. If you are not ready to show use in commerce and you file a request for extension of time, the USPTO gives you 6 more months. 6 months go by. You pay another fee. You pay for your attorney if you're hiring an attorney to do the filing. At that point, you can file either a statement of use. You can file a statement of use at any time in here, but these are just to show you the timeline. You can file a statement of use, or you can file your second request for extension of time. As before, if your statement of use is accepted, and the USPTO will review it, and they may not accept it, but if they accept it, you'll get your registration. If you're still not ready to show use in commerce, you file your second request for extension of time. 6 months go by. So now we're talking, okay, again, you have the same option. It keeps repeating. You have the option, file a statement of use or file your third request for extension of time. So if you can file your statement of use and you can show you're using your trademark in commerce for the goods or services described in the trademark application, and if the USPTO approves it, you get registration. If you cannot, you file the third request for extension of time. The USPTO charges a fee per class, and of course, an attorney charges a fee also. I'm just going to go through this. So 6 months, I forgot to write 6 months there, but each one of these lines is 6 months. 6 months go by. You have a deadline. These are USPTO deadlines. You must either file it, otherwise your trademark is abandoned and the USPTO will cancel it. Okay, that's what happens if you don't do this. You either file a statement of use. If it's accepted, it will be registered, or you file your fourth request for extension of time. Pay the USPTO filing fee, pay your attorney. Okay. 6 months go by. The deadline comes up again. Okay. You can file your fifth request for extension of time or your statement of use. If it is accepted, the USPTO will issue your registration. Your fifth request for extension of time is the absolute last one that the USPTO will allow you to file. You've requested an extension of time for 6 months. You have 6 months to file your statement of use. You cannot request any more extensions of time. So what that works out to is 3 years from the date of the notice of allowance to file a statement of use. That is the absolute maximum time that you have as an applicant. If the statement of use is accepted, your trademark is registered. Now, that's the timeline, and that is why it can be substantially more expensive if the applicant is not using the trademark in commerce. When the application is filed, they can end up paying. I've had people pay all 3 years. Every 6 months, you pay the fee to keep the trademark application alive. That's the only way to keep it alive. So that can add up. As I said, hey, if you want to do it, it's fine. I just want people to understand up front. And the last kind of like detail I want to talk about here is it's called an insurance request for extension of time. So let's say you got your notice of allowance and you're on top of it. You've got a website, and you got it up. You got it up right after, right? Let's just say you got it up 5 months after the notice of allowance. So you're very close to the end of the 6-month deadline. You can file a statement of use, but if the USPTO does not accept it, you're out of luck. Okay. So what is recommended is that you file what's called an insurance request for extension of time. So even though you're going to file your statement of use at month 5 after the notice of allowance, you're also going to file a request for extension of time, because what that means is if the USPTO does not accept your statement of use, you get that time up to the second, you get that additional 6 months. You get another 6 months to try to show use in commerce. That's a little bit more detailed than this. I just wanted to specifically go over the timeline because it is something that I get asked very frequently. I hope that explains it. Again, just to say, if you're filing it as in use, and just to go back to the very beginning here, if you're filing it as in use, after the opposition period, after the publication period, if there is no opposition filed, you get your registration. No more USPTO filing fees until you have to renew at 5 years. Okay, but no more, your trademark is registered. There's no more application fees. Otherwise, you go off into this notice of allowance and you go into this page. So that is a very short explanation of the timeline and the difference between an intent to use application and an in-use application. And the last thing I want to say on that is sometimes when people are filing as in use, it's more clear. It's easier to accurately identify the goods or services. Often when people have services, they have a website or something, they say they're going to be providing something, they file it as intent to use, and by the time they get around to actually making the website up, let's say it's an app, sometimes it's slightly different than the words they use to describe it to the U.S. Patent and Trademark Office. That can cause issues. Again, something for a different video. I'm trying to do several different topics, and discuss each one discreetly. But anyway, my name is Sharon Adams. I'm at Adams Law Office. Contact information will be in the video down below. I help many, many people get their trademarks, and I'd be happy to help you. Thank you.